Hi, hello, welcome to another Kingsfield webinar on disruption and COVID-19 in our global projects. I'm joined again by my colleague John Fotherby, and also by Alex Johnson again from Freeths LLP for the second webinar in this series of three. Looking at the disruption and caused by COVID-19 and based around our case study, which we offered up in the last webinar. So perhaps let's just do a quick recap of the way we like to do these webinars. So this again is going to be a 60-minute webinar. We're going to try and hold back 10 minutes at the end. For those of you that have been dialing into these webinars, you know that's a challenge for me to try and squeeze 10 minutes, but let's do our best nevertheless to get those questions in. So if you have questions during the course of this webinar, please type them into the question panel below, and that will get filtered through to me, and I will pass that on through to John and Alex to address. So we're basically going to run it the same as before with a conversation between John and Alex around where we are now in this webinar. Let's do a quick recap of webinar one. Okay, so we set up a case study scenario, and if you look at your control panels down in the bottom right-hand side, hopefully you'll see that there are some handouts in there. You can refresh your memory of the case scenario. And basically, we were looking last week at where are we in our projects? What are the problems? What are the things that you're experiencing? And as a kind of a recap of the case study itself, we've got an owner who is a public quoted utility. The EPC Contractor is a three-party joint venture. And in the wake of coronavirus, the EPC Contractor has closed down the site without any kind of formal notice, and there's been various delays across the supply chain which need to be addressed. The purpose of this second webinar today is to say, well, how are we going to deal with this? What are we going to do in terms of relief and remedy? And John and Alex are going to share their thoughts on that. But let's kick it off. Also, if I draw your attention to the handouts, you'll also see in there that we have today's case scenario, which is the second handout that you can see in there. And this is a letter from the owner to the contractor. The third handout in there is a link to a video, which I don't want you to look at right now, okay? I want you to look at us and listen to this, and you're going to look at that before the third webinar next, not next week, the week after that. At the end of the webinar last week, we didn't have any time for questions. Those questions have been answered by John and Alex, and they are the fourth attachment in the handout. Please take a look at those and get back to us if you have any queries, but try not to look at them now. Let's just focus on what we're doing here. So I think I'm going to read out the client's letter, and maybe you can look at that as well. But just before we do that, I'm just going to ask Wayne, who's in the background as usual. Sorry, Wayne, I forgot to introduce you. If he could bring up our first poll of the day, I would like to know who we have in the room with regards to all you out there. So just please select one, which best category suits you. And just while you're starting to do that, I'm going to quickly read through the owner's letter here. So here we go. Our on-site personnel have informed us that EPC Contractor unilaterally closed the site in response to the COVID-19 pandemic. Our personnel were prevented from entering the site by your security staff, as were other contractors and suppliers who were trying to access the site to carry out their works. There has been no specific government direction or advice to close construction sites. As such, works on construction sites must continue in accordance with any guidance given by the government or public health authorities. You have no right under the EPC contract to close the site and stop the works You are required by the EPC contract to proceed regularly and diligently with the works. Closing the site and stopping the works is a breach of contract. By this letter, under the terms of the EPC contract, you are notified that this is a breach of contract. That this breach of contract must be rectified within 10 business days, pending our further notice of termination. We fully reserve all our rights under the EPC contract. So that is the owner's letter that I said also you can see in the handout. Okay, so poll results, okay, not so many owners this time, 54% contractors, welcome to you all. Welcome to the subcontractors, welcome to the 4% of vendors and suppliers in the room, and hello to the consultants and advisors. Thank you so much for joining us. Okie dokie, so I just want to remind everybody as well that actually in the first webinar, 90% of you said that the first thing they would be looking to do in these projects is collaborate with the owner. And so we're going to be addressing that in here, and we'll hopefully find out what some of you think this means in terms of collaboration. So I think I've probably spoken enough already. I think I'm going to start with Alex, actually. Alex, I wonder if you could start, please, by summarizing this letter. What does this mean for both the parties?
Thanks, Carl, and good afternoon, everybody. Thank you for joining us again, or welcome if you didn't join us the first time. This letter puts the parties at what I would describe as polar opposite positions. In England, we say their parties are at loggerheads. They've got completely opposing interests, and this letter summarizes that from the owner's point of view. The owner is trying to wash his hands of this problem. He's resorting to the contract that he has. It's a very contractual letter. It's the kind of letter that I have written for clients, and it's the kind of letter that I have received from other parties on behalf of clients. And the owner's legal team probably wrote it. It's designed to protect the owner's position, and it's designed to keep the owner's options open as far as possible without waiving any of its legal rights, which of course it may wish to rely on later on. And from the contractor's point of view, as we left webinar one, we realized that the contractor's in pretty deep trouble on this project. Just to quickly recap, the contractor didn't properly engage a process under the EPC contract which permitted him to close the site, such as force majeure. He potentially triggered a termination event by abandoning the works because it wasn't clear whether the site closure would be temporary or whether it was in permanent site closure. He possibly allowed the owner to accept a repudiation of the EPC contract. He possibly allowed the owner to draw on any bonds that the owner has. And he's inevitably caused delay, which is probably critical for the period while the works are suspended, which means that liquidated damages will be levied. So it seems, in summary, Carl, the parties couldn't be further apart at this point in time.
Excellent. Thank you, Alex, for summarizing that. I would like to ask you all out there a question then based on what you've heard before, what Alex has just said, and what you've read. So Wayne, if you could bring up the next poll for me. I want to know whether you out there think that the owner's letter increases or decreases the chances of collaboration as being a solution to this problem, being as 90% of us want to collaborate. At least that was from the poll in the first webinar. So does it increase or decrease the probability of collaboration here? So once we get the results, and then Wayne, be more than happy for you to flick that back over. Okie dokie. Thanks for that. I think just leave that up for the moment then, Wayne. And I think we're just going to hand that back to Alex to talk about that, I think.
Yeah, that's very interesting. Basically, 2/3 of you think that this letter decreases the chance of any collaboration, and I would be inclined to agree. I think if I had a vote, which I didn't, that's the way I would have voted as well. John, do you have any observations?
I think that it's not surprising. We know that this is a lump sum turnkey EPC contract, and the nature of those contracts tends to separate the interests of the parties and really put them into positions where there's inflexibility to address problems like we're talking about. So it doesn't surprise me at all. And of course, that letter just reinforces the position, as you've explained in the last few minutes, the owner's position. He's relying on the contract, he's hiding behind the contract, and as long as that persists, the opportunity to find a workable solution that both parties can sign up to becomes less and less. So I think the delegates are right with their assessment.
Yeah, I absolutely agree with all of that. Before I go on to talk about the letter, I'd actually like to have another poll, if we may. Wade, could we bring up another poll? I'd like you to vote on whether you think the client is in a strong or a weak position. So is the owner in a strong or a weak position? See what you think, and maybe as you think about that, consider why you think that might be. So is the client's position a strong or a weak position at this point? And we'll just wait for the results of that. Yeah, so that's 83% of you think that the owner is in a strong position. And I'm absolutely not surprised. You know, if you receive that letter, it looks very strong. It's been drafted to look like it's putting the person that wrote it in a very strong position. It clings very, very closely to the contract. But I'm going to suggest that we could look at this another way. Despite the way it's been written, I think the owner's letter actually reveals quite a weak position. If you look at what it actually says, he's saying, I want no part of this problem. I'm relying on my contract, which gives me strong arguments. But as we know back from webinar 1, yes, the owner has some strong arguments, but he doesn't have any practical answers to this problem, really. So in a way, I think this letter is quite a desperate one, because what it's saying is fix the problem or else. But at this point in time, I don't know what the or else is going to be. So I think, and I'm sure John thinks as well, that the owner can be persuaded to collaborate in this instance, and John will explain why shortly. Just let's address the immediate issue for the EPC contractor. If you receive this letter, you have to do something about it. So how is the EPC contractor going to deal with this letter? And I think what we should do is look at the legal and contractual implications behind this letter. I won't read all of it. I will just summarize it and give you my thoughts. Hopefully you've all had a chance to have a look at it. The first paragraph simply summarizes the facts that arose from the case scenario, which is that, yes, the EPC contractor closed the site and it prevented people from accessing it. The contractor probably can't dispute those facts because that's what happened. The owner then goes on to say that there's been no specific government direction or advice to close construction sites, and as such, work on construction sites must continue in accordance with any guidance given by the government or the public health authorities. Now, this is quite a useful point for the contractor, because it suggests that the owner has at least acknowledged that work can't continue as usual, which raises the question of, if work is going to continue, what are the restrictions and modifications that may apply after the works can recommence? Now, those will have a time and money impact, and we'll have a look at some of that later. So there's a little glimmer of hope in that paragraph for the contractor, I think. The owner has reiterated the fact that there's no right to close the site under the EPC contract and stop the works. That's probably correct. As we established in webinar 1, usually a contractor is only allowed to suspend the works in certain situations, for example, where it hasn't been paid, or where a force majeure situation has properly been notified. Contractors is required to proceed regularly and diligently with the works. Yes, absolutely. Any EPC contract will have a similar obligation, and closing the site and stopping the works is a breach of contract. Yes, in principle it is, as we established in webinar 1. Now, the interesting paragraph in this letter: by this letter, under the terms of the EPC contract, you're notified that this breach of contract must be rectified. Well, what does it mean to rectify this breach of contract? my view is that this is a breach that cannot be rectified because the site has been closed, and it's been closed for a period of time, and that can't be undone. So what rectification is really hinting at here is a mitigation or a minimization of any further problems. And really this is about, well, when are you going to restart? When will the works recommence? Within 10 business days, that's a very, very short period of time for a large project such as this, where an unprecedented event has occurred that has prevented work from being done at all. So there will be numerous methods of working that have to be introduced once any closure is over. There will be reprogramming, there will be resequencing, there may even be some rework if work has become damaged or failure to be properly protected in the meantime. There are a myriad of things that the EPC contractor has to consider before he can commit to restarting. So 10 business days is, in my view, simply not really workable. And the reason it's there is probably this EPC contract applies this period to many breaches of contract, most of which I would suggest are less serious and can be more easily rectified. For example, failure to submit a drawing on a particular date can be much more easily addressed. It also hints at what could be the owner's endgame, which is the notice of termination. So this letter effectively is a cure notice. It's a chance for the EPC contractor to cure the problem. Otherwise, the owner will exercise its rights to terminate. Whether it actually does or it doesn't, we don't know at this point, but it's a threat. And finally, the owner signs off by saying we fully reserve all of our rights under the EPC contract. And that's always good practice. Whichever contracting party you represent, you never want to waive any rights under a contract because you never know when you might need them. So it's good to state that you will always fully reserve those rights. So in summary, this is a serious letter. The contractor must not ignore it because there are serious consequences if it does nothing. It will simply make a bad situation even worse. If the contract is terminated, well, this could expose the contractor to very serious financial implications, as well as the loss of the revenue for the remaining works that it expected to receive. The EPC contract will certainly set out what losses the owner is entitled to on a termination, and those can include an element of profits. So it's important also for the contractor to understand any limitations on liability and also its potential exposure for termination, and that requires legal advice.
Great stuff. I hope you all got that because there's a lot of good stuff in there. So in a moment, I'm going to invite John to talk about what the contractor's project director should be doing or should at least be thinking about. But before I do that, I'm going to try something a little bit live and see how this works. You should see, hopefully, in the side of your screen here, I think that's the right side, the chat box. And I'd like you to put in there your comments, just some quick, brief comments to the organisers and panelists here. If you were the project director, what would be your top 3 objectives at this point? So I'm just going to let this run for 20-30 seconds just to see what I can eke out of you out there. So just be thinking about that. If you were the project director, what would be your top 3 objectives at this point? And just put those in the chat box to the organisers and panelists, and then just hit send. Encouraging to see we've already got our first question, by the way, and we'll be hopefully on schedule to be able to deal with that at the end. If you can't think of 3 objectives, by all means, just think of 2 or even 1. Anything which means I'm not left hanging here, filling the space, waiting for comments to go in.
It is a big problem.
So nothing yet. You do need to press, just in case some of you are doing this. There we go. They are in, okay, I'm being told that they are in asking questions. They are asking in questions, okay. Okay, all right. So my brief wasn't as clear as I perhaps would have liked then. I'll take the hit on this one. Let me just make this box a bit bigger so I can see what we're coming through. Okay, so so I've got one from, oh my gosh, it's really scrolling through fast. Just give me a second. Gosh, you're all definitely doing what you should be doing. So let's start with, I hope you've got a pen and paper, guys, because you might want to write some of this down. I'm gonna go to the top here. So that's the first one. That's a question. That's a question. Okay, so it looks like okay, so how to get reimbursement for indirect costs from client owner during, maybe that's not it, maybe that's a question, sorry. We got one is respond to letter. I think Thomas has said respond to the letter. Sorry, I'm trying to separate out the questions from the comments here. So I've got Mark has said make plans to reopen the site. Luke has said define and document the logic for the closure, presumably not done accidentally without a plan. Bear with me. Okay, one from Hannah. Minimize potential costs. Mark again, establish UK position on COVID-19.
Yeah, we're all still waiting for that.
You getting this? Yeah, keep waiting, Mark. Luke has come in again. Understand vendor subcontractor exposure. Jason's got all three, I think. Well, not all three. He's got a full house of three. Get back to work. That seems like a direction. Keep staff safe and protect our position. Not visible, this question on screen. Sorry, Venkatesh, I'm not sure what that means. Okay, VCAS, I think it's VCAS, sorry if I've pronounced it wrong. Notify owner before closing site, inform about the difficulties faced due to the project situation, and let's see if I can, gosh, yes, this certainly worked very well. Thank you all for this. Thomas has said, arrange a meeting with the client to discuss a way forward. Thomas, you know too much. Mark again, attempt to engage with the employer further. Yes, that's all looking very good. Now, Hannah, do everything possible to keep moving on the program. Thomas, get the site up and running. Elizabeth, re-establish relationship with the owner. VCAS, respond to the letter. I think I'm coming towards the end of them now. Respond to the letter substantiating and justifying reasons for closure. And Luke is pouring, just full of good ideas. Luke, thank you for that. Consider credible potential mitigations, accelerations on remaining works to recover schedule and understand the cost to this present to the client. I think that is pretty good. Make plans, yes, Nick. Make plans for as to what measures needed to reopen the site. And Jesus, work jointly in the mitigation plan. And I think, Nick, I'm going to let this be the last one because I think we need to move on. Substantiate and justification for previous delays. Okay, so that's what you think. I'm sure John's run out of lead now. Well, or ink, any one of those. So John, perhaps I can be quiet and you can lead on. Project director, 3 key objectives, please.
Yeah. First of all, let me just say that I think that the feedback there is very good. It's sort of what I would expect. A lot of those things are not necessarily objectives, but are needs and actions that need to be taken. And basically, I don't think I'd disagree with any of them in that context of things that have to happen in this situation. So I think we're getting a big list of things that need doing. If I'm project director in this situation, then I think I would have 3 key objectives right at the moment, and those objectives may shift, but we are, as Alex has pointed out, with this letter, in a bit of a difficult situation because and you voted as well about the potential for engagement with the client is somewhat limited. So my objectives at the moment would be, first of all, prevent the risk of the situation escalating legally and contractually. and at the same time avoid the owner from taking precipitous action. Now, whether that's drawing bonds or trying to terminate the contract or anything that would put the contractor into a worse position than he's in at the moment. That's the number one objective. My second objective would be to find common ground between the owner and the contractor that can be the basis for meaningful discussion. And in particular, I'd be seeking out there, what are the parties' real interests in this situation? We know what the positions are. The owner's made it clear in his letter, but where do the interests lie here? And my third objective would be to create a platform to have the opportunity in due time with the owner on discussions about delays, costs, other issues where we might need contractual adjustment. But I wouldn't see that as an immediate issue for discussion. I wouldn't want to give anything away. And at the same time, I'd want to have the opportunity to revert back to that platform to continue that discussion at the right time. So those would be my three key objectives. I think the key is securing the owner's buy-in to the solutions to the problem. We know what the problem is. We don't have to address that any further. But the question is, what are the solutions and what can we discuss and agree on? And in that context, I think there's two issues to really get bottomed pretty quickly. Confirmation that the owner wants the project finished, or as Alex sort of hinted, is this an opportunity to terminate this contract and do something different for whatever reason that they think? And the second thing is, if he wants it continued, then he's already inferred in his letter that he's recognized that it would have to be finished in a way that's quite different to that originally contemplated before COVID-19 occurred. So based on that, I would have immediate actions, and a lot of people have said, first is answer the letter and answer it within 10 days from the date of the owner's letter. Confirm to the owner that the contractor will open the site within 10 days of that letter. Now, opening the site is quite different to starting the work. And as Alex was pointing out, it's going to take a bit more time to get everybody organized to actually start doing things on site, but you can open the site. And the owner's complaint was the fact that the site was closed. So let's show the willing way forward by confirming that. You can confirm nothing else at the moment because you don't know enough and you haven't done enough planning. And my third point would be to request a meeting with the owner within the next 2 days from that letter, not from our letter, but from the owner's letter, to address and agree with the owner the plan for actually reopening the site. Because of the circumstances, this really needs to be done by agreement because there's implications for more than just the contractor and the owner at stake there. So I've got a question to Alex now. What do you think about that approach as a letter, Alex? Is it sufficient? What else should be said? And perhaps more importantly, what should, as a project director, avoid saying in this letter?
Yeah, thanks, John. It's absolutely the right strategy. The letter cannot go unanswered for the reasons I mentioned earlier on. But having said that, this is a very delicate letter that needs to be written, and it's one that, in my view, needs legal advice and it also needs technical input. It will be a contractual letter. The owner has sent a contractual letter, and so the contractor needs to give a contractual response, which means this letter will be sent on an open basis. It won't be protected by without prejudice privilege, which we'll talk about a bit later. It's going to be a document that will be on the project record. And in this letter, the contractor needs to protect his position, first and foremost. He's in a bad position, but doesn't need to make it worse. He certainly shouldn't make any admissions. But I would not recommend that the contractor admits that he breached the contract or indeed give anything away that suggests he was at fault. I believe he should take the high ground I think he should find reasons why the action was justifiable, and I think one of the comments even said that. If there are good reasons why it closed the site, then they should be stated. If there aren't any good reasons why it closed the site, then don't say anything at all about it. I think the contractor would be well served to avoid a tit-for-tat contractual response, because that will sort of keep the parties at loggerheads, and it will set the path towards a dispute. The contractor has to show that they're committed to resolving the issues that the owner has raised, but very much protect its own interests. The contractor certainly shouldn't make any concessions or try to engineer a settlement in an open letter like this. That is where without prejudice comes in, which we'll talk about. The contractor should certainly reserve his own rights, so preserve his future rights if this does all end in a falling out, and rights have to be exercised. They shouldn't be waived in this letter. And I think finally, really what the letter needs to do is, we've heard, you know, an hour and almost an hour and a half of agony for the EPC contractor, and so he needs to stem the bleeding, and he needs to start to make his position a proactive one rather than a reactive one.
Great, thank you. I think that's helpful, and I can recognise that sort of advice. I'm just thinking about how we start the conversation in a meeting with the owner. Wayne, can you suddenly concoct a poll for me? I'd like to ask everybody, what are the common grounds for discussion? And I'd like to select a few that I'll tell you. First is the owner's need for project completion, COVID-19 that is neither party's responsibility. Oh, you've done it, very good. Delay to completion, additional completion costs, and personnel health and safety. This is basically not just selecting one, but which of those would anybody think is a ground for basis for discussion with the owner?
There's three leaders there, John.
Yes, people do make life difficult. Thank you very much, everybody, for that. I'm not surprised that we get a response like that, because basically these are areas where discussion will have to take place. But I think we have to slim it down to subjects that are less likely to be contentious for an opening discussion. And if we just look down the list, the owner's need for project completion, well, he said, we're assuming that he wants to go ahead, okay? So that definitely could be a subject for discussion, to have his confirmation, yes, we want to finish the job. COVID-19 is neither party's responsibility. Well, I think that I'll come back to that in a minute. I think that is quite an important one. Delay to completion, well, yes, there will have to be a conversation at some stage about that, but whether I would open the discussions on a presentation of what the extension of time and the delay is, I'm not so sure, because the risk is that the two parties will be even further apart. There won't be a room for serious discussion. The positions will be fairly polarized, and the same goes for the costs. There will have to be discussions on the costs, there's no question about it, but the question is when and under what circumstances. And there's a large support for personnel health and safety. I think that linked to COVID-19 are the real grounds for opening discussions, a common grounds. Because, first of all, neither a public authority nor a public authority owner or a contractor can be seen to be flouting health and safety issues. And in any case, the contractor is going to be under regulations to comply with for health and safety, as well as government directions, etc. So, and it's going to be a very difficult situation for an owner to say, I don't want to talk about these issues. I want you to open the site, but I don't want you to talk about these issues. It's not realistic. He cannot do it. No serious owner can ignore it. So if we say COVID-19 is a no blame situation, regardless of whether we've served notice of force majeure or not, it doesn't really matter. It is a no blame situation. Neither party caused this, and it is paramount that the health and safety requirements are met, both from a legal point of view and a morality point of view. So there we have grounds to start having a discussion. So if we've got that basis, Alex, I'd like to ask you, do you think the owner would be willing to meet? And if so, why? What's your views on that?
This depends how reasonable your owner is, I think. My personal point of view on this would be, I think as bad as things are for the contractor, they're actually also pretty bad for the owner. Despite the appearances that the owner tried to put across with its letter that we looked at earlier on. And if the owner is being in any way pragmatic and prepared to face the reality of the situation, I think he will think, well, I am possibly in the worst position out of everybody, because the revenue stream he was trying to generate from this project is being delayed, and also his costs are going up. So the goal of completing the project for him is getting further away into the horizon rather than closer. So coupled with the fact that, as we looked at in webinar 1, the owner has got power contractually but no real strength, because his letter doesn't give solutions. His letter is just a roadmap towards a dispute. So my view of the owner's situation is he has two options, both are pretty bad options. He either has to somehow continue with the contractor who has defaulted under the contract, or try to replace that contractor. Now, neither of those are easy options, and both have substantial impacts on the owner's cost and also the time taken to complete the project. So I think if he takes a deep breath and looks at this, then he's got little to lose by at least meeting the contractor.
Yeah, I think that's right. He has little to lose, has he? And he may see an opportunity that is better than his other options. So I think I would see that. Now, let's assume then he says yes, and we're going to have a meeting. Then, from the contractor's point of view, what needs to happen to ensure that we're protected as the contractor legally? What are the things that we need to be aware of? What things do we need to take care of?
Yeah, any meeting like this should be held on a without prejudice basis, or on a without prejudice subject to cost basis, and also declared to be subject to contract. Now, those are three phrases that get thrown around quite a lot, and they are invariably used wrongly. What those mean: so without prejudice is a type of legal privilege that arises under English law that protects any genuine offers to settle a dispute from being disclosed to a court or to a tribunal. This means that a court and a tribunal shouldn't see any documents that are marked without prejudice, as long as the substance of those documents is that they are a genuine offer to settle. And the reason we have this privilege, this protection, if you like, under English law, is because it allows parties the freedom to speak openly about resolving the problems that they have, without worrying about the information that they give being used against them later on. And the only real distinction between without prejudice and without prejudice save as to costs is that the save as to costs element means that a court tribunal can see those documents, but only for the purposes of assessing a costs award. If you're familiar with English law, you'll know that the rule is generally that the loser pays the winner's costs. And finally, subject to contract means that there's no binding agreement until a contract is signed. So this effectively protects the negotiations that might be going on, not only in this meeting, but perhaps in any follow-up correspondence or follow-up meetings that the parties might have. So it's very important for the parties both to ensure that this is documented in the minutes that are taken. So take minutes, ensure that they're accurate, and ideally both parties should sign them. And if those protections are in place, I think this would create an environment where both parties can express themselves properly without the fear that what they say could be used against them later on. So I think against that backdrop, assuming we can achieve all of that, John, what do you think the key issues are for the EPC contractor to raise in the meeting?
Well, as I said just a couple of minutes ago, I think that the meeting needs to present a proposition to the owner that looks far more attractive than any alternative that he has, whatever those options are that he's thinking about. And as you were saying earlier about the need to start the site and things like that to get back on with the works, is probably the most economic way. So to support that, we need to be putting something on the table that is he can at least listen to and think about and consider. So I think where I would start is a reflection upon an explanation of why we are where we are, and come back to the point that COVID-19 that really drove this situation is neither of our faults. And I would stress the contractor's position that our personnel safety is our primary concern. We have legal obligations there, but it goes further than that. We have morale obligations, and particularly in these extreme site circumstances. And I think I would say that, you know, we were really obliged to close the site. Whether we served a notice of suspension or not is sort of a bit of a legal niggle at the moment in the overall scheme of things of why we did things. Well, yeah, we can be blamed for it. We didn't do it properly, all those sort of things. But it's far more serious than that. And I would want to make the point that as a contractor, we take care of our people, and that's a priority. I think then I would go to an outline plan. It's things that many of the delegates put in the vote that they've just recently had for recommencing the work. It's got to get started, and there's got to be a sound plan. If you're trying to have this meeting with it, you know, inside 10 days from the owner's letter, there's going to be a huge amount of questions to answer. So you cannot start making firm propositions about actions that are going to be taken. You can outline the scheme and say this is what we intend to do, but of course we have to do further research and establish some facts. But I think first of all, I'd talk about reopening the site. I'd again emphasize that personal safety remains a primary concern, plus compliance with the government's regulations and guidelines for construction sites, etc., whilst COVID-19 exists. And it is a health and safety risk. And my view is that this is a given. Neither party can back away from this. They have to deal with it, and they have to address it. The other part of reopening the site is what needs to happen practically from an organisation point of view. And this involves the owner and the contractor, because the owner's got other people working on the job. He's got his own people. And we need the owner's buy-in to the process that we're going to have to follow. If we look at the recommendations from government of what needs to happen on site with staggered starting times and meal times and personal protection and social distancing, all the rest of it that's going along, which is completely abnormal, then both parties had better understand what that means and what their contribution is to it. So I'd want to address that. And I think the point I'd want to make is that it's in our interest, it's in our joint interest. It will be pretty bad news if the project was a reason for a new wave of COVID-19 or a spike in COVID-19 that people are talking about simply because we didn't take care and we didn't plan and we didn't liaise and collaborate on how to open and run this site. I think having got over that, then you can start talking about, okay, well, the challenges of remobilising subcontractors, you know, it's got to be practical. We've got to get people back onto site. It's not easy. There's got to be discussions with them. It takes time. Similarly with vendors, material deliveries, how we're going to receive materials, etc., due to restrictions on site and such like. And then there's the actual challenges of work performance, given the restrictions due to COVID-19. We're not being able to put as many people where we want to put them. There's the distancing, there's the productivity issues, and so on and so forth. So there's a lot of issues, practical issues, where we need to draw the owner in to at least support the decisions, agree to them, and that this is the plan forward. And I think that there's two more things I would address in that meeting. First of all, I'd ask the owner what his focus is on priorities. Given the situation that this job is going to be delayed, there's going to be no doubt about that due to the circumstances. Where are his priorities? What does he need in order to be able to see something in performance? Is there part of the plant that we can focus on? Can we make some alternatives? What's the options? And the purpose of that is to draw the owner into the planning activities and the commitments of what needs to happen. And it gives him an opportunity to have a voice in that and to have his say. And I would resist any requests from an owner that are absolutely, unachievable and unrealistic. We have to be fairly tough on that. And the last point is, agree the next steps. This is the first in a series of meetings that have to take place. I wouldn't try to settle anything with this. I wouldn't try to get a deal in this meeting. I would simply have it as a first discussion that's going to have to go on for a little bit of time before we actually get there. And in that next step, I think it's about preparation and presentation of a revised execution plan, a new target completion schedule, a resource plan, cash flow plan, etc. And it's things that people were talking about in the survey a few minutes ago. Have you anything to add to that? What's your thoughts?
That sounds really comprehensive to me. I think those are exactly the types of things that the EPC contractor should be thinking about, putting itself on the front foot, taking control of the situation. Because I think the parties have to recognise that despite all that's happened between them, actually they still share a common goal. They still want the project completed, both of them. And so the issues aren't really about whether the project gets completed, it's more about how it gets completed. So this discussion is about the how, and this discussion shouldn't be a blame game, because that just goes nowhere in my view. And I think that, I suppose the other observation I would make is how this situation shows that contracts don't really always account for everything. Sometimes, as much as we like them to, parties have to be, flexible and open-minded and collaborate.
Yeah. Okay.
Guys, listen, I know there's so much to say. I'm just going to see if I can get you to speed up a little bit. As usual, we're kind of galloping away with the time. I know there's some really great stuff still left to come. I'm just reminding you that this is a bit of a time check for you guys, okay?
So briefly, on that prompt then, Alex, briefly, I'd like to know what happens if the client says, no, I don't want to meet. Briefly, what should we do? What's it mean?
Yeah, that's not a good position. My own view is I don't think there's anything for the owner to lose in attending this meeting. It's without prejudice, so they're both protected, as I explained before. I think if he declines to meet, then the contractor has to somehow up the ante. It has to run a harder contractual position and even brinksmanship in some open correspondence, while continuing its efforts to secure the meeting on the without prejudice basis. And I think if I was advising the contractor, I'd be saying, look, my actions in closing the site were justifiable, they were appropriate, they were temporary, and if I'd have done anything else, I would be being irresponsible. So, you know, press the health and safety point that he was simply complying with his obligations and this was the right thing to do. And I would ask the contractor to produce the evidence that supports that. So if the owner declines the meeting, I think the contractor has to fight fire with fire, try to secure the meeting, but, you know, create the impression that the contractor is going to make this pretty difficult if the owner doesn't collaborate.
Yeah.
Okie dokie.
Yeah.
So John, I'm sorry guys, I'm moving you on quickly now, just aware of the time. John, so let's think about this meeting then, John. How's the contractor going to prepare for this meeting? What kind of practical steps, you know, can and should the contractor be taking?
Yeah, Carl. Well, first of all, I think we agree this is an absolutely critical meeting, and it needs to be well prepared and rehearsed, because there's a lot of questions that will come up. And as I said earlier, it'll be the first of several meetings that's going to take place. So we need to look at how we're going to stage those meetings. I think that it's an approach needs to be adopted that is about authenticity, credibility, and transparency. Trying to push your way through this by, you know, anything that's anti to those will not work very well. I think first of all, crucially, there needs to be a unanimous agreement in the contractors' joint venture as to the strategy and action plan. All partners need to be on board. In this situation, you can't afford to have a difference of opinion in the joint venture. So that's the first thing I'd want to do. And then it's about thinking about the meeting itself and where we're going and what's the real drivers, what are the things that are going to get us eventually into an agreement. And I think I'd like to explore with the delegates today what they think would be the prime interest in this situation. Wayne, can you run it up? So again, you can vote for more than one of these items, but where do you think the contractors, if you were the contractor, what would be your prime interests? Yeah. Right. Excellent response.
There's a clear winner.
Yeah, I think that the combination of demonstrating a competent and reliable contractor and ensuring that the people are not at risk are two inseparables, really. I think that the other three are things that we have to deal with. We have to find solutions for. There will need to be action plans, but they follow on in subsequent meetings. So I think that our interests are really being seen to be reliable, because this is going to prevent the owner from taking alternative action. And again, we're reinforcing our health and safety policies about taking care of people. So just to continue, Carl, with what we do, I'll go through these things fairly quickly. I think my first view is that in preparation, you need to keep this at the project management level. And the contractors project management delegation needs to be kept to minimum. So you probably project director, construction manager, project controls manager, procurement, possibly commercial contracts, and most crucially, HSE. We're playing a big game with health and safety. You need your manager in there who's running this. I think in preparation is confirm the meeting with the owner together with the proposed agenda and the names of positions. So you need to see who's on the other side, who you're going to be faced with, and confirm, as you suggested, that this is a meeting without prejudice, which again is comfortable for both parties. I think it's a sensible situation. Before you get into that meeting, you've got a very short amount of time to prepare, but you need status on intelligence and data. And I think the first thing is to understand where the owner is. What's known about his position? What's his needs? Where do you think his real interests lie? And some of this may be a little bit of supposition, some of it may be hearsay, some of it may be fact, but you have to get a picture of where the owner is and what you're confronting. And then, of course, you need your own internal project status and forecast for performance and delivery, engineering deliverables, where are we? We know what it says in the case scenario about status, material and equipment, what are the key vendors, and what is going to be the big challenges to those key vendors who are going to be pretty instrumental in getting the progress going. Same with the subcontractors, what's their resource availability, what's the possible deployment on site, how many can we get in, what trades, etc., etc. And then what's our own project team availability? What's the cash position? Because this is going to be fairly important, A, practically to fund the operation, and B, for discussions with the client, because the money is going to be an issue fairly soon. And then a look and assessment at the key risks. What's going to prevent us from achieving a reasonable startup? What are the issues that's in the way? And an assessment of the additional costs and key drivers for these. It's really important to differentiate on the costs that are applicable to dealing with this situation, separate from those costs that would have been incurred had COVID-19 not happened. So I think that for this first meeting, that's what I'd want to go in with, so that I'm prepared. I can answer questions. I might not be able to give firm commitments on anything, but at least I can address the issues and know where I stand, which will convey confidence to the owner that we're getting a grip of this situation. And again, we'll be able to continue that discussion then. And I think that's it, Carl. So, Alex, what about preparing for the negotiations?
Yeah, sure. Just to round things off today. Back in the first webinar, I think we had about 90% of our participants who voted for the contractor engaging the owner as the best strategy. And we've talked a bit about collaborative working today. I think we should look at what that really means. And a dictionary definition of collaboration is it's the act of two or more organizations working together for a particular purpose. And I think that's where we are now. If we're preparing for these settlement negotiations, I think collaboration is a very, very sensible strategy in the current climate. Certainly since COVID-19 became an issue middle of March, I've been advising all clients to collaborate, no matter what's happened and no matter where they are. Some clients close their site, some clients deciding whether to close their site. You know, a lot were asking questions after they'd already done something. So my advice to them was, well, you know, you're either in a pretty good position or you're in not such a good position. But I think either way, the route map out of this is one where we all work together. And recently the UK government has taken a similar position. The advice of the Construction Leadership Council is that conflicts simply should be avoided at this time. And it's my own personal view that a COVID-19 arbitration or litigation will result in no winners. Because these are not typical events where one party is responsible and they're claiming against the other, and frankly they shouldn't be treated like that. These are neutral events that has an effect on everybody. So if you need to negotiate, well, you need something to negotiate about, and I'm going to leave that hanging there for you to join us in the next webinar where we explore that.
Great, super.
Thanks, Alex.
I'm sure somebody taught me once that you should never begin with an apology, but I'm going to start with an apology because we're out of time again and we haven't made it to the questions. So my please, Vikas, Venkatesh, Matthew, Jesus, my apologies for not being able to deal with your questions here and now. I shall make sure that my esteemed colleagues here will address these shortly, and we'll either get that sent out to you via email, or we'll do the same again with the handouts, and we'll plot them in for next week. Not next week, sorry, for the 4th of June, which is a third webinar. You've got a week off next week. So I think so. We've done this is the first 2 of the 3. The final one, continuing with the collaborative working theme. We're going to be addressing, as Alex just said, negotiations, and as John alluded to here, you know, the importance of interests over positions. Remember the link in the handout there, the Getting to Yes, the Power of Listening by William Ury. It's a 15-minute video, a TEDx. Yes, it's a short video to watch, which will give you some pointers for the next webinar. Like I say, the link is in the attachment. But essentially, we're going to be looking at how can we put the contractor's case together, and look at what the basis is for any negotiation. So as I said, this is on the 4th of June. The event is already up on our website, so you should be able to go and register there. If you still have some questions, I think you probably have some seconds left. Otherwise, just email it through to myself, John, or to Alex, and we will add those to the list. And I think that pretty much does it. Thank you to Wayne in the background, as ever, driving this for us and funneling questions through. Thank you to you all out there for that, for sending in your questions and engaging with us again and giving us your time. Thank you to Alex for his legal perspectives and insights, and thank you to John for his practical insights. And that's it, I think. Thank you all, and we'll see you on the 4th of June. Goodbye.
Good luck, everybody. Goodbye.